So the first topic that we're going to talk about here is complying with the Oregon Workplace Fairness Act. This is a law that was passed in 2019 as Senate Bill 726, but many of its key provisions did not go into effect until near the end of 2020. So understandably, this law may not have been on everyone's radar or on the top of the priority list as we battle through the pandemic. So my goal here is to give all of you an overview of this law and some strategies for remaining compliant. So first of all, what is the Oregon Workplace Fairness Act? It was a law that was passed to address workplace concerns raised by the Me Too movement. So many of you will recall in recent years stories about prominent celebrities and other personalities, figures, political figures as well, being accused or even convicted of sexual assault, sexual harassment, things of that nature. A big part of that story too, of course, was that victims of harassment and assault and discrimination were silenced from telling their stories and sharing their experiences due to strict confidentiality, non-disclosure provisions, and the like. So what Oregon did, among with several other states, is they passed legislation in an effort to try to prevent that from happening in our state. The result was three pretty key changes to Oregon employment law that I'm going to go over in greater detail in this presentation. But generally speaking, the law made these three changes. First of all, there's now a mandatory written requirement to have a written anti-discrimination or anti-harassment policy. There's now a 5-year statute of limitations on certain types of employment claims, which is now one of the largest in the country, longest statute of limitations in the country. And there's restrictions on certain types of written employment agreements, including settlement, severance, and separation agreements. Just want to note, as we'll discuss, this law is quite broad in application. While people think of Me Too and they generally think of just sexual harassment, sexual assault, things of that nature, the law is actually much broader than that. It applies to many more claims, and this law has teeth as well. So it can be quite costly to be non-compliant with this law. So you'll want to make sure that all your policies and documents are in line with the legislation. Okay, so first and foremost, the mandatory written anti-discrimination, anti-harassment policy. As of October 1st, 2020, all employers were required to have a written policy that contains the 6 provisions that I'll discuss on this slide. So if you don't have a policy that covers these 6 provisions, now would certainly be the time to do so. I just also want to note that means it applies to all employers, even if you just have 1 employee in the state, you need to have a policy. Okay, so the first provision is that the policy must have a process for reporting, quote, prohibited conduct. And this is a term that I'll be using a lot today throughout the presentation. It's also a term from the statute. And when I say prohibited conduct today, I'm referring to one of 2 things, either discrimination or harassment on the basis of race, color, religion, national origin, sex, sexual orientation, age, marital status, expunged juvenile record, a person who's in uniformed services, or on the basis of disability. It also refers to sexual assault, which is a defined term from the statute, and it's defined as unwanted conduct of a sexual nature that is inflicted or compelled upon a person by use of force, manipulation, threat, or intimidation. Secondly, the policy must identify the person to receive reports of, again, prohibited conduct, as well as an alternative. So it's not sufficient just to have 1 person in your policy, but you have to have at least a second. It's fine to identify them either by title or by name, but I do want to point out that you want to be sure you're monitoring the policy over time to make sure it's still up to date and includes the proper contact. So, for example, if someone moves out of their position or that position's eliminated, you just want to make sure that your policy constantly reflects who employees should be reporting to. Third, the policy needs to disclose which claims are covered by the new 5-year statute of limitations, and we'll go over that shortly. It also needs to state that employers cannot require employees to enter non-disclosure or non-disparagement provisions, as well as definitions of both. There are some exceptions to this, and we'll cover that near the end end of the presentation, but policy still needs to include this language. Fifth, the policy must include an explanation that employees who are claiming to be aggrieved by, again, prohibited conduct may request otherwise prohibited provisions, which we'll go over, but for now they essentially mean non-disparagement, confidentiality, and no-rehire provisions in the context of a settlement or severance agreement if they are given at least a 7-day revocation period to change their mind. Last but not least, the policy must include a statement advising employees to document incidents of prohibited conduct. So that's certainly something new that I'm almost fairly certain that many of your policies did not include pre-Workplace Fairness Act, so something to definitely keep in mind as well. If you have questions or were unaware of this policy or want to compare your policy to a model template policy, I'll note that the Oregon Bureau of Labor and Industries has a model policy on their webpage. You can go there and take a look at it. I think it's useful certainly for some things. For example, it includes, certainly deemed by BOLI to be compliant definitions of non-disparagement and non-disclosure provisions. I would just encourage employers to, make a policy that makes sense for the workforce, and even consult counsel to make sure that your policy is compliant if you want to, personalize it a little bit for one that makes sense for your workforce. Okay, there's also a requirement in the law that the written policy must be disseminated under 3 circumstances. So first, the policy now must be distributed to employees at the time of hire. So this is certainly something that might have already been a practice for many employers, but certainly at this point, all employees should be getting the policy when they're hired. One thing I'd note here, a good practice, I think, is certainly to get a signed acknowledgement from the employee that they received the policy when they were hired. Secondly, the policy needs to be generally available within the workplace. It's not defined what that means in the statute, but I think common sense would say that generally means, a common area, maybe a place where you keep your other workplace posters, like your OSHA posters or your overtime posters, things of that nature. Now, many of you probably have fully or partially remote staff. So a good place to house this policy for those employees would likely be on your internal intranet page if you have one, or otherwise sending them a copy via email. Third, employers must also give the policy to employees at the time they disclose information regarding prohibited conduct, again, discrimination or harassment, by the person in your policy who is designated to receive the complaints. So this, I think, is going to be an important time for you to be thinking about making sure your managers or other personnel who are identified in your policy to receive the complaints, to make sure that they are aware of the circumstances under which they need to provide the policy to employees. I think that employees or the persons designated to receive the complaints, I don't think employees need to be saying certain buzzwords like "I have been discriminated against" or "I have been harassed." I think you should teach or train these managers to err on the side of disclosure. If an employee comes to them and says something that could be reasonably interpreted as disclosure of harassment or discrimination, the managers should provide the policy. Okay, so turning to the statute of limitations, as noted, there's now a new 5-year statute of limitations for certain types of employment claims, basically 2 categories here. First, discrimination or harassment under ORS 659A.030.082 or .112. And again, that's the same prohibited conduct I mentioned earlier. I'll say them again now: race, color, religion, sex, sexual orientation, national origin, age, marital status, expunged juvenile record, person in a uniformed services, or disability. So any of those claims are now subject to a 5-year statute of limitations in Oregon as of September 9, 2019, meaning that those claims, even if conduct occurred in 2019, those claims are not going to expire until at least 2024. One thing, and this is, by the way, a huge thing. I mean, it used to be a 1-year statute of limitations. The fact it's 5 now is massive. I think Washington's is 3 years. 5 years is certainly one of the longest in the country. So something to keep in mind. But I also want to point out that not all employment claims are now subject to the 5-year statute of limitations. For example, claims under the Oregon Family Leave Act are not subject to the 5-year, neither are claims under the sick time law or retaliation claims under ORS 659A1199, which are whistleblower retaliation claims. So just something to keep in mind. The second category with the 5-year statute of limitations are violations of basically the Workplace Fairness Act prohibitions on certain written agreements, including settlement and severance agreements that we'll cover in a couple slides. And just note that that statute of limitations went into effect starting October 1, 2020. So a long look back period for violations of those unlawful workplace practices as well. So with this 5-year statute of limitations, I would tip all of you to consider revisiting your document retention policies. Given how long this 5-year statute of limitations, it's very likely going to be the case that, as in other cases, documents and emails are likely going to be your best defense in many cases. You know, it's with this 5-year statute of limitations, you could be dealing with situations where you know, the coworkers who were witnesses to the alleged discrimination or harassment are no longer with the company. It might be more difficult, you know, to have them available as witnesses to tell your side of the story. So if you're in a situation where you don't have any documents and emails due to your lower end or shorter document retention policy, and you lack witnesses, that's going to be a pretty tough situation to be in if you are facing litigation from events that occurred, you know, maybe even 5, 6, 7 years ago by the time the case gets to trial. So I would particularly consider revisiting the policy for if you have a high turnover workforce, because again, if you have a lot of turnover and your witnesses are gone and you don't have policies or documents or emails to look at to defend the events that happened, it could be a tough situation. Okay, so turning to restrictions on certain types of employment agreements. So this really gets to, you know, I think what was originally intended to be the primary purpose of the Workplace Fairness Act. And so what it did was it made it an unlawful employment practice for employers to enter into agreements that contain any provision that have the purpose or effect, and I think that's important, or effect of preventing the discussion or disclosure of prohibited discrimination, harassment, or sexual assault. So now I just want to point out here that agreements is very broadly defined. Essentially, any agreement that is entered into between an employer and employee as a term or condition of employment for the receipt of benefits at the outset of employment, etc., anything that could be construed as preventing the employee from talking about prohibited conduct is essentially off limits now. And I'd also note that it doesn't apply just to employees, it also applies to prospective employees by statute. So applicants, if they claim that they've been, you know, discriminated against for some of the on the basis of a particular status under the statute, you can't then have a settlement agreement with them that contains these provisions unless one of the exception applies that we'll go over shortly. Also, the law applies not just to on-premises conduct, but also conduct that occurred off-premises as well. So essentially, it does not matter if the conduct happened on a work trip or a company holiday party, things of that nature. Just because it happened away from work doesn't matter. The Work and Workplace Fairness Act applies. Getting to the teeth of the statute, violation of these restrictions can be quite costly. Essentially, employees can file a complaint with BOLI, or they can go straight to court, or both, which is often the case. They have the full penalty of damages available, including compensatory damages, meaning emotional distress, punitive damages. Have with the employee that is not compliant. So really making sure you're dotting your I's and crossing your T's on this issue is essential. I want to point out that there is at least one exemption under the law, and that's for employees who are tasked by law, and that's a term from the statute, to receive confidential or privileged reports of prohibited conduct. Now, tasked by law is not defined, so I would be, it's unclear what that means. One plausible interpretation, I think, is that it applies to the employees who are identified in your written policy to receive the reports, but that's not exactly clear. We might have to wait for the courts to give some additional guidance on that, so I would be wary of using that interpretation for the time being. What about confidentiality during investigations? Obviously, this was a very common practice pre-Workplace Fairness Act, and it's still a common practice in many states. In fact, Washington State had passed a Me Too law shortly before Oregon's Workplace Fairness Act. They still allow employers to require employees to maintain confidentiality during such a workplace investigation. However, in Oregon, given the language of the statute, I would certainly not tell an employee that they're required to maintain confidentiality during a workplace investigation. I presume or suppose it would still be acceptable to express your preference that they maintain confidentiality, but certainly wouldn't do anything that would suggest to the employee it's required. So just something to think about for those of you who have operations in both states. Okay, so what about separation, severance, and settlement agreements? So we've mentioned it a couple of times now. So the statute does make an exception that allows employers to include non-disparagement, non-disclosure, confidentiality, as well as no-rehire provisions in any separation, severance, or settlement agreement, but only when an employee who is claiming to be aggrieved or of prohibited discrimination requests that those provisions be in the agreement. So essentially, if employee who's claiming to be aggrieved of race, color, religion, national origin, etc., sort of discrimination, if they ask for these provisions to be included in a settlement agreement, it's allowable. But there are still quite a few unanswered questions given the language of the statute. I won't go into all the plausible interpretations, but given the way the statute is written, it's many of us agree, I think it's unclear as to whether or the extent to which an employer may still include these restricted provisions, i.e. non-disparagement, confidentiality, no rehire, when an employee hasn't claimed to be aggrieved by prohibited conduct. So for example, if they're just claiming that employer unlawfully withheld wages, but nothing else, and the employee hasn't requested the provisions. One interpretation is certainly that under those circumstances, it is allowable to include these provisions in such agreements without an employee asking for it. But I certainly would shy away from relying on that interpretation, or at least be careful about doing it until the courts weigh in, because I think there are other plausible interpretations. We don't have clear guidance from the Oregon Bureau of Labor and Industries on this issue. And certainly I would expect to see litigation on this issue going forward. So in the meantime, until the courts give us clear guidance on what exactly an employer is and is not allowed to do in those circumstances, is to consider adding a disclaimer in your severance or separation agreements that essentially says, if you are going to include these sorts of terms, I would add something that says nothing in the agreement should be construed as prohibiting the employee from speaking about prohibited discrimination, harassment, sexual assault under 659A, .030, 082, and 112. And I would certainly work with counsel as well in when you're revising these agreements in those situations. One reminder again is that if you are in a situation where an employee has claimed to be aggrieved of the prohibited conduct, and they have requested these restricted provisions, non-disparagement, confidentiality, no rehire, you have to give them at least a 7-day revocation period to change their mind. Which brings us to the requests language. I would be very careful about doing anything or saying anything to an employee that could be construed as coercive into getting them to agree to or coercing them to request the non-disparagement, no rehire, confidentiality provisions. We don't have any case law guidance on this yet. We don't know what is and is not allowable by employers to do in this context. So be very careful on that issue. Last but not least on this slide, I want to point out that nothing in the Workplace Fairness Act acts as an express prohibition on confidentiality as to severance or settlement amount. So you keep that in mind going forward, that there's no prohibition on that, and that it shouldn't be an issue. Again, of course, and so long as it's not limited or broader, and going into talking about conduct that is about sexual harassment or discrimination or any other type of prohibited conduct. Okay, so what about dealing with harassers or accused harassers? The statute does provide some exceptions for employers in dealing with essentially the bad actors who have been accused or even found to have engaged in the prohibited conduct of discrimination, assault, or harassment. So essentially, an employer can include non-disclosure, confidentiality, or non-disparagement, no-rehire provisions if the employer has made a good faith determination that the employee engaged in the prohibited conduct or violated your written anti-harassment or discrimination policy. In addition, the statute made it possible for employers to void so-called golden parachutes, which, if you're unfamiliar with the term, essentially are agreements, employment agreements that call for the payout of oftentimes lucrative severance payments at the conclusion of or at the termination of an employment agreement. So I think the reason that happened is because oftentimes with many of the stories that came out in the media, there were these huge personalities at companies that had their employment agreements terminated because they engaged in prohibited conduct, but they still received $1 million payouts. So the Oregon legislature, I think, added this provision to address that situation and allow employers to void make such payments voidable so long as three requirements are met. First and foremost, the person had to have authority to hire or fire or exercise control over employees. So essentially, they have to be someone high up enough to have some control over employees. They can't just be some low-level employee. Second, the employer has to have conducted a good faith investigation, and the employee was fired in substantial contributing part for violating the written anti-harassment or discrimination policy. And of course, the good faith investigation led to that conclusion. I would caution employers who are considering either of these avenues to first consult with counsel, because for example, if you're going to be avoiding any sort of separation or severance payments that were otherwise due to an employee based off of your good faith investigation that they engaged in such conduct, it's still very likely that the employee could still assert claims against you for breaching the contract, for not paying them what they should have been paid or what they feel they should have been paid. And same thing too with imposing non-disclosure, confidentiality, no-rehire provisions in situations where you feel that the employee is engaged in prohibited conduct. There may be potential ramifications down the line if essentially you're taking the position that yes, this employee did harass or did discriminate against other employees. That's certainly something you want to talk about with counsel, I think, before going down that route. So something to keep in mind. Okay, so if I could leave you with a to-do list following today's presentation, my presentation, here are 4 things I think you should consider moving forward. First and foremost, of course, ensure that you have a written policy that's compliant. Again, that law went into effect October 1st, 2020, so now would be absolutely time to make sure you are up to date. Second, update your hiring protocols, again, to make sure you're getting written acknowledgements of receipt of the policy, and train your managers for being aware of situations where they should be distributing the written policy when employees come to them with concern or disclosing incidents of discrimination or harassment. Prepare for the 5-year statute of limitations. Again, revisit your document retention policies to see if it makes sense to update them. And then last but not least, update or revise your employment agreements, including your form separation or severance agreements, to make sure it is in fact compliant with the prohibition on certain terms and provisions within those agreements. And with that, I want to thank you all for listening.